too. If you tweet us at C-SPAN, use the hashtag, please, landmark cases. Well, let's first start with the fundamentals. It's a First Amendment case. So a quick review of the First Amendment of the Bill of Rights. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. In the Tinker case, is a particular clause in the First Amendment that is pertinent, particularly pertinent?
Well, indirectly, yes. So no law abridging the freedom of speech. Tinker would clearly fall under the category of freedom of speech. In the particular instance, it was symbolic speech, but the court had already recognized that symbols can convey meaning and argument much as words can. But it was actually the 14th Amendment that applied to the school district, not the first. The 14th Amendment, which incorporated the First Amendment as against the states, because of course the First Amendment talks about Congress, but the 14th Amendment applies to the states, and the basic principles of the First Amendment commutatively apply to the states as well now.
With regard to schools, before this case came to the court, what was either the law or the custom?
Well, there had been the occasional case that upheld sort of student rights, if you will, or at least applied things to schools. So the Barnett case about having to stand for the Pledge of Allegiance, if you had an objection, though one might think of that as a religious case as much as a speech case. But in general, schools had a lot of leeway, tons of leeway to restrict kids and to maintain discipline and to do what they wanted. And if you look at someone, Justice Black's opinion, for example, or later opinions by other justices, schools had almost the role of a parent to the children, such that they could do what a parent could do and tell them to stop talking for whatever they wanted.